Well, this is fun. Let me just, I just want to make a couple points because David is incredibly eloquent and quite forceful, and I don't think any amount of talking is ever going to convince him that I'm right and he's wrong. But let me try. Let me encourage all of you that, we can sit up here and tell you about what you should read. You should go read these things for yourself. You should actually reread Justice Jackson's opinion in Johnson versus Eisentrager, which, despite apparently standing for a categorical rule, nevertheless devoted 15 pages of analysis to the question of whether the military tribunal that convicted the 22 petitioners properly had jurisdiction, a question that should not have mattered if they couldn't have won anyway. Right? In Eisentrager, you had 22 individuals who conceded that they were working on behalf of the German army in China for Japan after Germany had surrendered. There was no question as to whether they were subject to the laws of war. There was no question as to whether they could be handled by military authorities. And still, Justice Jackson spends 15 pages talking about these things. Instead of reading the Brookings Report, read some of these 41 habeas decisions. In Awad, Al-Awad, A-W-A-D, you have Judge Robertson upholding the detention of an individual on evidence that he calls, quote, gossamer thin, and that would never survive any possible standard of review in any other circumstance in any other courtroom. These are not liberal jurists who are putting their finger on the scale of the detainees. In this room, I should not have to tell you that the D.C. District Court is not exactly the Ninth Circuit. Although I would then defend the Ninth Circuit and you would be confused. But enough about me. Let me just say, I think we are, the more general question here, and I think the harder one and the one on which I suspect we will all never agree on, is what is the appropriate role for courts going forward? What is the appropriate role for courts to play in whatever we're calling the conflict against al-Qaeda and affiliated groups? And more generally, what is the role for courts to play in these kinds of questions that have at least historically been resolved largely outside of the courtroom? And what I want to suggest is I think there are important ways in which habeas is just different. David fears about civil suits about predator strikes. Some of you may know the Federal Circuit's 2004 decision in a case called El Shifa Pharmaceutical Industries Company versus United States. If you haven't, I'm shocked. And El Shifa basically is about Bill Clinton, remember him, his destruction of a Sudanese pharmaceutical plant in 1998. The owner of the plant brought a takings claim and said, you destroyed my pharmaceutical plant. And President Clinton said, your pharmaceutical plant was enemy property. And the Federal Circuit says, well, that's the end of it, right? The president's designation that he attacked something that was enemy property makes this a political question. Again, these are not courts that are looking to invent ways of controlling executive conduct. I think the reason why the habeas cases are different is because Justice Kennedy and his four colleagues on the left understand the unique role that habeas corpus was always meant to play, not in protecting the rights of individuals, but in allowing the courts to protect the executive from overreaching during wartime. It's a role the courts actually have always played. If you read the history books, it's a role that the English courts played in hundreds of cases involving prisoners of war during the 17th and 18th century. Now, we may disagree about the merits of these decisions. We may disagree that the court should be playing these roles. But as long as Boumediene is on the books, and as long as Boumediene is the law of the land, and if I can't say that Citizens United is wrongly decided, well, then I think we have to respect the fact that habeas plays a vital role in the separation of powers, and that the D.C. district courts, rather than running off the rails, have actually taken their responsibility to balance national security with individual liberty quite seriously, and have ruled for the government even in cases where the evidence was incredibly light. No one is talking about CSI Iraq. No one is talking about burdens of proof that resemble those of a criminal courtroom. We're just talking about more than the government's unsubstantiated assertion that you are who they say you are and that you are doing what they say you are doing. Now, maybe we disagree about what the standard of review should be, but I think time has now demonstrated that plenty of the people who we have previously held at Guantanamo were in fact just in the wrong place at the wrong time. You may say they are collateral damage, and that accidentally holding some innocent people is just inevitable, and I would come back to that and say, that bothers me. On the question of whether the criminal justice system should be protecting these people who want to do so much damage to us, let me just briefly read a quote that's been with me for a long time. In debating what to do with the Nazis after World War II, Churchill said we should just shoot them. Stalin said we should try them first and then we should shoot them. But the American position was a little more nuanced. As Justice Jackson would argue, we try them not because they deserve it, but we try them so that once we convict them using fair procedures, we will be able to say for all time that we proved to history that we were right and they were wrong. As he said in his opening address, it would be the most significant tribute that power has ever paid to reason. We don't do these things for reciprocity. We do these things because we're a liberal democracy. Thank you very much.
I'm glad you ended with Nuremberg. I'm glad you invoked Justice Jackson. First of all, the Nuremberg trials were military commissions.
True.
The difference between the fair, did you say fair procedures?
Sure.
The fair procedures of the Nuremberg trials and the procedures of military commissions, either under the Military Commissions Act of 06 and 09, are basically night and day. I mean, the rules of evidence in Nuremberg were flexible and sort of undefined. There was no right of appeal. I mean, the military commissions have multiple layers of appeal, including to both the military courts and to the civilian courts. I mean, I'd be quite happy and quite comfortable relying upon our prosecution decisions in the War on Terror on the precedent of the Nuremberg trials, particularly as described by Justice Jackson as the chief prosecutor of Nuremberg. I'd also be quite comfortable in relying upon Eisentrager as the critical decision for defining the scope of habeas corpus in wartime. Again, there's really no point to some extent, I suppose, to relitigate Boumediene. It is what it is, although we continue to litigate what Boumediene means, and that hasn't been settled. But, the dozens of common law cases that you cite, almost all of them, in fact, I think all of them, were situations in which you were talking about individuals who were either citizens or subjects of the Commonwealth, or within the territory of the country and in front of the judge himself who was making these decisions. Justice Kennedy himself, obviously a broad supporter of the right of habeas corpus, and Boumediene, was quite clear that there was not a single precedent in this court's history, nor did he cite any in Anglo-American history, in which a federal judge or an American judge was reviewing the detention of an alien captured abroad and held abroad by the military during wartime. So, again, this is all water under the bridge, except as it applies to Bagram. But, if we could agree on Justice Jackson, I'd be very comfortable.
Let me just, can I throw a short question back?
Okay, and then we should open up to audience, but go ahead.
My short question back would be, then why review the merits? I mean, Eisentrager, if the rule of Eisentrager is that aliens held outside the territorial United States have no constitutional right to habeas corpus, that's a 3-paragraph opinion, even for Justice Jackson. So why is it 22 pages reviewing the merits of their claims?
I'm prepared to stand on the decision Eisentrager fairly read, and folks can read it, as well as his observation that it could no more fetter our military commanders than to have their decisions challenged by the enemy in a federal court during wartime.
And Steve, lots of times courts will engage in dicta. I mean, Marbury versus Madison. If your view is right, Marbury would have been one line long.
And my con law students can tell you that's what I teach them.
There you go. So we all talk more.
Okay, well, it seems that our panelists have given you all a lot of reading assignments, but if there are any questions, please raise your hand and wait for the microphone.
We'll continue for a second round.
Oh, there's a question there.